Welcome friends, good morning. We are again here to discuss very important part of Indian Constitution and polity, and I, Dr. Mjesh Kumar, will discuss Indian Constitution and polity with you in much detail, but yet in a very simplistic way. So let us begin our class, but before that, just tell me whether I am properly visible or not, whether I am properly audible or not. That means, can you hear me? Can you see me? Just so that I could verify and then I could start the class. So I am waiting, and just tell me whether everything is fine or not. Yeah, so if everything is fine, then let us start today's class. And in the last class, we discussed some aspects of preamble. And if you remember till here, we have discussed some major portions of preamble. What is preamble? From where the preamble comes? What is the source of preamble? What are the main ideals that are inherent in the preamble? So sovereign, socialist, secular, democratic, republic, then popular sovereignty, justice, freedom, equality, fraternity, unity and integrity, dignity of individual. Each and every word we saw. And we also saw the political constitutional debates related to those concepts. Then we went for critical evaluation of the preamble also. What is the shortcoming of our preamble? That means, what are the criticisms of preamble? Then we also went through the significance of preamble. Why preamble is significant for India. So today let us finally discuss some of the issues related to preamble, and just tell me, is everything fine? सब ठीक है? मेरी आवाज जा रही है? सब चीजें आप तक जा रही हैं? Everything fine? Yes. So now let us discuss certain issues related to preamble. Issues. Today let us discuss certain issues related to preamble. Issues related to preamble, and first issue is whether preamble is a part of constitution or not. Whether a part of constitution or not. So this is first issue, whether preamble is part of constitution or not. Second, whether preamble is amendable. Whether preamble is amendable or not. Whether preamble is a part of constitution or not, and whether preamble is amendable or not. So these are two issues that are very important regarding the preamble to our constitution, and I have taken these two issues together because most of the constitutional experts and even judiciary have treated these two issues together, and they are basically two faces of the same coin. So why I am saying like that, these two issues are somehow two faces of the same coin. So let us see why. First is whether preamble is part or not. That means, it is a part or it is not. And second issue, whether it's amendable or not. So if preamble is part of the constitution, then definitely it will be taken to be amendable. And if preamble is not considered to be the part of constitution, then taken amendable. So if preamble is considered to be a part of the constitution, then it would be definitely amendable. But if preamble is not considered to be a part of the constitution, then it would not be amendable. Why? Why I am such assertion? Because if you go through the process of the Constitution of India, then the amendment procedure, the procedure of amendment to the Constitution is mentioned in Article 368. Now at this moment we are not going to discuss what is actually that procedure, because that is part of our syllabus, and therefore when that topic comes, then we will elaborately discussing this whole process of. We will see that how does article begin. 68 says this constitution can be by XYZ method. So XYZ method is at the moment, because that is a part of the syllabus and that we are going to discuss separately. The whole procedure of amendment, its criticisms, issues related to amendment, everything. Article 368 and its words. So what is that concern? Article 368 begins with the word, this constitution can be amended by XYZ process. Now this constitution can be amended. So here, if we take first assertion, preamble is a part of constitution, then of course, if we take this assertion that preamble is part of this constitution, that means, or when the article 368 says this constitution can be amended, then preamble is included. Preamble is under this constitution, and if preamble is included under preamble can be amended, because then this constitution can be amended XYZ, then XYZ procedure is applicable to preamble, because preamble is taken to be a part of the constitution. And if preamble is taken to be a part of the constitution, then when 368 says this constitution, that means constitution including all parts, including preamble, by XYZ procedure. But the second assertion, that is preamble is not the part of the constitution. When we say, or if we take second viewpoint, that preamble is not the part of the constitution, it is something separate from the constitution, it is not a part of constitution, then what does it imply? It implies that preamble is not covered under this expression, this constitution. That means this constitution means constitution without preamble. So 368 XYZ procedure shall be applicable to constitution without preamble. Why? Because preamble is not the part of this constitution. Therefore, these two issues are basically two faces of the same coin. If be part of the constitution, then article 368 applies to preamble, because 368 applies to every part of the constitution. So anything can be amended except the basic structure, that is a different thing. But anything can be amended, any part can be amended. Then taken to be a part of the constitution, then preamble is not the part of the constitution, therefore preamble cannot be amended. So this is the crux of debate. Now let us see how judiciary has defined this whole issue. Because matter came time and again before judiciary, so we will see from the beginning how this whole, how it was through judgments, and 2021 what is raised in a case right down called Berubari case. Berubari case 1960. This was a presidential reference case. Berubari case 1960. In Berubari case 1960, Supreme Court ruled no. That means questions. What are those two questions? Is preamble a part of constitution? No. And since it is not part of constitution, so is it amendable? No. So two things you must remember. In Berubari case, Supreme Court says to the just keep on writing some comments so that I could know that you are getting the point. If it is clear, mention it via your comment, and I am waiting for those comments. So if any problem you have, then also you have to comment. So in Berubari case, so keep on writing, commenting, good morning, whatever. Berubari case 1960. In the Berubari case 1960, Supreme Court is not the part. Therefore 368 is applicable to the constitution without preamble, it is not applicable to the preamble. And since 368 is the amendment procedure, therefore amendment procedure is not applicable to the preamble, and therefore preamble to the Constitution of India is not amendable. So taken by the judiciary in 1960 Berubari case. And remember Gajendra Gadkar, he was the Chief Justice who pronounced this decision. And remember Gajendra Gadkar's statement, preamble is the key to the minds of framers of the Constitution. Preamble is the key to the minds of framers of the Constitution. That means Gajendra Gadkar says that if you actually want to understand what the founding fathers thought about this Constitution, what was their mind, So therefore, that is always found in the preamble. And if you amending this, then a day will come when in preamble also most of the things will change. And if most of the things will change in the preamble, we would be able to read the minds of the framers of the Constitution. How we would be able? Because words have changed. And therefore, Gajendra Gadkar says that preamble is the key to understand the minds of the framers of the Constitution. Preamble cannot be. So this was first important case. Now, second important case, the same issue was again Bharti case 63, and hope you well remember Keswanand Bharti died this last year 2020. Was a Mahant, priest of a Keswanand Bharti. In this issue was raised. Keswanand Bharti case, again this issue was raised. Keswanand Bharti case, whether preamble is a part of Constitution or not. There were many issues involved. So Keswanand is a different case, very holistic case that we are going to discuss in the topic. That is also, but case dealt with many things. So one issue related to this preamble, whether preamble is a part of the Constitution or not. And now in case changed its viewpoint, and now it pronounced yes. That means it answered is a part of the Constitution, is a preamble is amendable. Therefore, preamble can be amended. So in this way, in Keswanand Bharti case, the whole strand of, and now that preamble is a part of the Constitution. What was the argument of court? In Keswanand Bharti case, Supreme Court ruled that if we make preamble an exception to the amendment procedure to Article 68, as it was done in the Golaknath. So if it is made an exception, then what will happen? Will remain static. Preamble will remain static, and it will reflect the realities of 1950 when elected, and it did years. I need something new to be incorporated, to be removed. Changing time needs some changes. But if we won't be able to amend the preamble, then what would happen? Finally, the preamble became static. It will become irrelevant. It will reflect the realities of as useful, as relevant. 2000 will be irrelevant. That will be removed from preamble. Taken place in the field of political philosophy. Something better than secularism has, for example, come. Then that will be incorporated. That can only be done through amendment procedure. So Supreme Court is relevance of the preamble. In Keswanand Bharti case, Supreme Court formulated the theory of basic structure or basic feature. Structure doctrine. Formulated the doctrine of basic structure. So what is the basic structure doctrine? Again, this basic structure doctrine in too much detail. We are going to discuss in much detail. But here just, since the word has come. See, what is basic structure? Basic structure doesn't any in the Constitution. So first of all, it is not the contribution. Source of basic structure is not of India. It doesn't come from the Constitution. Then from where does it come? So either a parliamentary legislation may be the source, or a judicial pronouncement may be the structure. Is judicial pronouncement. Question comes from where the basic structure comes? From judiciary's ruling, and that was in Keswanand Bharti case. So in Keswanand Bharti case, Supreme Court ruled. In Supreme Court what is the limit of amending power of the parliament? To what extent parliament has the power to amend the constitution of India? And in Keshwanand Bharti case, Supreme Court ruled that parliament has the power to amend everything in the constitution except the basic structure. So parliament has full amending power, and it can article of the constitution, it can remove anything from the constitution, and it can incorporate anything in the constitution, but it cannot abrogate, it cannot adversely change the basic structure. So Supreme Court interpretation of basic structure, that basic structure is the core fundamental values, those basic norms without which constitution cannot exist as a living document, those ideals, those words that for the survival of Indian constitution, and they just try to understand it with the help of an example. I will be elaborating these cases, but when time comes, but here also we will give some references, and when basic part of Keshwanand, everything will come, but just here think what is basic structure. So in Keshwanand Bharti case, Supreme Court says, first of all, basic structure is not 2020 prelims, अभी जो था 4th October last year, उसी का भी मेंस चल रहा. So in that prelims, this was a question that I am explaining. Source is not constitution. It has come from judiciary, in which case Keshwanand. And what Supreme Court structure are those essential features, those fundamental features of the constitution, without which Indian constitution is incomplete. So this building has many components. It has a roof also, it has a wall also, and it has the base also, foundation also, जिसको नींव बोलते हैं, cornerstone. Now if we remove the roof of the top floor, and if it is a 10-floor building, roof of the top floor, then building will survive. Yes, one floor is damaged, but on the 9th floor, 8th floor, we can work and we can stay. That is not the basic feature of the building, because without that, building can survive. But if we dig the foundation of the building, then nothing can survive, the whole building will collapse. Now that are those foundational stones, they are the basic structure of the building. Similarly, apply this example to the constitution. Everything is not the basic structure, but whatever is essential for the survival of the constitution, that is the basic structure. Then who will decide what is the basic structure? Who will decide? Because the general definition that those most important provisions of the constitution, without which constitution is incomplete, it cannot survive, that is basic structure, those most important provisions. But what are actually those provisions? Which word of the constitution? Which part of the constitution? What is that? The Supreme Court says in Keshwanand case that at one time we cannot say, and therefore the list goes endless. Remember, the list goes endless. That means Supreme Court says that whenever a matter comes before us, that is secularism a basic structure, then that day we will say, yes, it is a basic structure or not. Is democracy basic structure? Is federalism basic structure? Is rule of law basic structure? Whatever, is this article basic structure? Is Article 21 basic structure? Whatever is basic structure and whatever is not. This we will decide from case to case. So in different cases we will tell, and gradually one by one, more than 25 things have been categorized as basic structure. It can keep on increasing also. It is endless. So in next case, something else can be taken as the basic. So this is an endless journey. And if you see the general things, so rule of law, parliamentary democracy, sovereign, socialist and secular nature of democracy, supremacy of constitution, balance between fundamental rights and directive principles, federal nature of polity, these by and large more than 25 things have been categorized as the basic structure. So what now in Keshwanand Bharti Supreme Court says? In Keshwanand Bharti case, Supreme Court says that yes, you can amend the preamble. In Golak, no, preamble is not the part of the constitution in Golaknath, and hence you cannot amend the preamble. But In Keshwanand Bharti case, Supreme Court says, yes, preamble is the, and yes, you can amend it, but with one exception, that you can amend everything in the constitution and everything in the preamble also, but not the basic structure. So basic structure may be found anywhere in the constitution. It may be located in the fundamental rights, it may be located in the directives, it may be located in the union government, and it may be located in the preamble also. So if preamble contains a basic structure, that basic structure cannot be amended, cannot be removed. Is the basic declared in SR Bommai case as the basic structure. So secularism cannot preamble of it. But for example, if fraternity has not structure, can be amended and can be removed from the preamble. So what is that emerges in Keshwanand Bharti case? Preamble is amendable. Yes, preamble can be amended, and constitution is also amendable. So preamble can be amended. But if some basic structure is found in the preamble, then that basic structure cannot be amended. Now this position was later on maintained, I am saying not upheld, in Minerva Mills case. Minerva Mills, similarly LIC case. So in later cases that are related to amendability of preamble, the same stand that was promulgated, was upheld, was approved, was so same thing still continues. So let us see what is the latest position regarding amendability of the was given in Keshwanand Bharti, and in later cases only was reiterated, it was repeated. So write down what is the present status. So write down now few lines. Yeah, those who are late, don't be late, because you missed a very important debate and you must see it in the video. So write down what is the present status. The present status regarding amendability of preamble goes like this. Present status regarding amendability of constitution goes like this. Present status regarding amendability of preamble goes like this. First, preamble is a part of the constitution. This statement prelims you will take as true statement. अभी इस पे सवाल आया था, इसीलिए मैं कह रहा हूँ कि 4 statements are also the questions. So first statement, what will be taken as true? Preamble is a part of the constitution. Is it a part of the? Why? Because though in Berubari, Supreme Court had ruled that this was changed in Keshwanand, and that was upheld in various cases. This position is that yes, preamble is a part of the constitution. Then second position, preamble can be amended. So this is also to be taken as true. Preamble can be amended. Preamble can be amended. So second instance is yes, preamble can be amended. It is amendable. Then if a basic structure is found in the preamble, if a basic structure is found in the preamble, then that basic structure cannot be amended and removed. If a basic structure is found in the preamble, then that basic structure cannot be, removed and removed. That basic structure cannot be amended and removed. So these 3 statements are to be taken true. अभी 4 statement आया था prelims में, last year prelims 2000 latest prelims 2 महीने पहले, and these 3 statements if you know, then you could have answered the question. And also that this basic structure doctrine does not have the constitution, the result of judicial pronouncement. So the source of that preamble has been amended only once. So now it is very clear that it can be amended. So let us see how many times it has been amended. It has been amended only. Preamble has been amended only once, and it was in 1976. It was in 1976 through second amendment. It was in 1976 through 42nd Amendment. So through 42nd Amendment, 1976, preamble was amended. So only once, तो ये याद रखना. Now what was done? Nothing was removed. So an amendment can to the preamble and can abrogate or remove something also. But this 42nd Amendment did not remove anything. Rather, it was socialist, secular, and democratic. Socialist, secular, and democratic. Three concepts it added. That 42nd Amendment. Our preamble was like this. Sorry, democratic. Oh, it was a grand mistake. Just read not democratic. Socialist, secular, and third was is not democracy. Just correct it. That was a bug. I corrected it. Three things were added. So, integrity. That means before 1976, what were the words in the preamble? Sovereign Democratic Republic. These were the three words. Sovereign Democratic Republic. But now word became Sovereign Socialist Secular Democratic Republic. So two words there. And here now the word was unity and so and added, and if you go by word, so four words were added. Socialist, secular, and. So and is also a word. And integrity. And today it is sovereign, socialist, secular, democratic, and republic. So only once the amendment, 42nd Amendment, nothing removed. Only this added, only few concepts added. So here we come to this first topic, though it took some time, but we completed each and every word, and I tried to explain each and every word found in the preamble and also the debates related to this. Now what you have to make a notes of all this. I have already dictated everything. Whatever I could not dictate, I explained it through chart also. So you have to make a fair copy of this. You have to go through it twice, thrice, 4 times. If you don't want to read a book, you can leave that. Always you can find this once, but it is the base. And after this, you can read any book, you will definitely understand. Else you have to revise it and then try to solve a prelims as well as mains, UPSC and all PCS exams. And hopefully, this is my challenge, hopefully, if I have met the fair, that means you have completely got it. So rarely you will miss a question. This you can try yourself. Words are not enough. Actually, it has to be proven through experience. So go through your 10 years खरीद लो, उसमें देखो अगर नहीं होता है then do. This is so extensive that questions cannot go beyond this. So go through this and try to this. If you want to do some more interesting experiments, then just first finish it 5 times, 6 times. So if you have got everything, go through any book. Then whoever you consider to expert in Indian Constitution and polity. So of course, कई होते कि would not be to offend him. किसी को offend नहीं कर. Just our knowledge in comparison to him or her. So we'll go with Sir, madam, we have started. There is one Dr. Manjesh Kumar, he is teaching us. Think fruitful or not. Whether we have covered the topic holistically or not, this you have to politely ask here. Therefore, kindly, you are a great expert and ask a few questions. Maybe objective, maybe whatever. Ask few questions that are difficult from this topic to answer those questions or not. And let us see what happens. You won't be demoralized, that I promise. If you actually 3-4 lectures, if you those lectures mind, then definitely you will answer almost all the questions. And after that, तो आप कह सकते हैं, sir, can I ask few questions? Then ask. So democracy and see the impact. वेरी एक्सटेंसिव, और मैंने आपको इतना कोई अपने पे चैलेंज, दिस इज अ चैलेंज ऑन मी, ये पता नहीं फेल कर गया, बट यू सो एक्सटेंसिव, सो रिलाई ऑन दिस, अप्लाई कर, you must read books, then also these notes will be enough, and this you can test via this way. So here we complete the first thing, that is preamble. My basis of conceptualization. So after preamble comes part 1 and part 2, but part 1 is something different, union and its territory, and 2 is citizenship. So that we will also discuss, but first we will discuss 4 things in series: preamble, fundamental rights, directive principles of state policy, because are interrelated, and all of them contain the philosophy of the constitution. So there is linkages, whatever is there in the fundamental right, freedom of thought, expression, belief, faith and perceive, that you will find in fundamental right also. That was is the, but fundamental right now will start. That is a very long topic and one of the most important topics. So let us today begin with the topic fundamental rights. Fundamental rights, each and every aspects of fundamental rights. We will reach each and every aspect of fundamental rights, but before that, let us start with any book, but still the note has to be completed, so facts also shall be there. Fundamental rights, the whole notion of fundamental rights has been taken from the United States of America. So the concept of fundamental rights has been taken from, the concept of fundamental rights has been taken from the whole concept of fundamental rights has been taken from the United States of America. So source of fundamental rights is America. This second important fact, fundamental rights are placed in part 3, third part. Fundamental rights are placed in part 3 of our constitution. Part 1, union and its territory, part 2, citizenship, and part 3 is fundamental rights. And in part 3 we have from article 12 to article 35, so these are the articles 12, 13, 14, they are till 35 have fundamental rights. So these are some basic facts. In any book you will get these facts. We have to start, and then we have to discuss all the important issues and all the articles related to fundamental rights. So first let us start with the definition. In our constitution, fundamental have not. Let us see what actually is the definition, how the scholars have defined. So write down the definition of fundamental rights. Fundamental rights definition, write down. Fundamental rights are those fundamental rights are those rights. Fundamental rights are those rights which are moral. 2 words you must have in your mind, which are essential for material development of individual. Fundamental rights are those rights which are essential for material and moral development of individuals. Which are essential for material and moral development of individuals. Material and moral development of individuals. And hence enjoy, and hence they enjoy special protection of our constitution, and hence they enjoy special protection of our constitution. Again I am repeating, fundamental rights are those rights which are essential for material and development of individual, and hence they enjoy special protection of the. Every right cannot be a fundamental. Are those rights which are the most important one. The most important rights are fundamental rights. They have been placed in part 3 as fundamental rights. They have been categorized as fundamental rights, the most important. Why most important? Because These rights are development as well development. So what is material development? Material development is we get health care. So for example, freedom. Freedom is a fundamental right, because if I have freedom, right to freedom, then I can run my business independently. That will give me money, wealth, and that will be something material development. Similarly, education. Education helps me to get employment. So that is the worldly dimension of education. But at the same time, if I am a free person, then it leads to development of my personality also. I am a different type of individual. In the golden cage, might be having everything, but cannot match the sky that has nothing to it, but still freedom. So if I am a free person, then I am a morally different. So moral upliftment also is the result of fundamental rights. Similarly, education. Through education, I get an employment, naukri milti hai. So that is the material aspect of education, but at the same time, educates me to understand Gandhi's philosophy, to go through Buddha's, to know what is right and what is wrong, to go through Platonic theory of justice, Amartya Sen's theory of justice. So actually, education also raises my mental level. It makes me a better individual. It helps in the development of personality of an individual, and hence that is moral. So material is worldly and moral is extra worldly. It is mental, it is related to character, it is related to knowledge. And fundamentally, most rights that are essential for material as well as moral development of an individual, and hence second part of special protection of the constitution. That means other rights like constitutional rights, like legal rights, they also have the protection of the constitution, but special protection is granted only to the fundamental right, and they have been given by the constitution itself. And therefore we may say that constitutionally they are superior. In what way they are superior, that we are going to see just in this lecture. But they are superior to other rights. They are superior to other rights. So that is one aspect. What is the definition of fundamental rights? Fundamental rights are those rights which are essential for material and moral development of the personality, individual, and they enjoy of the constitution. So this is the most basic thing. I have started with the most basic, zero level, with the question, what is a fundamental right? So here we further, to expand this whole notion or to extend this debate, we must know, are there some other rights also in India or in Indian constitution except these fundamental rights? So what are those, and in what way these rights which are called fundamental rights, in what way these fundamental rights enjoy special protection of the constitution? So these two issues we have again to discuss, that rights also. And if there are other rights, then how those other rights are constitutional inferior rights? Yes, in Indian constitution we have different rights in India. Rights in India. So let us see what are the rights in India. So if you see Indian scenario, then we have first of all fundamental right available to citizens and some rights to foreigners also, fundamental rights. Then second set of rights is called constitutional rights. So let us try to differentiate what is a fundamental right, constitutional rights. And third that we have in India is also called statutory rights. So let us try to differentiate technically between fundamental rights, constitutional rights, and legal or statutory rights. Definition wise, we saw that this is the most important right, essential for both material as well as moral, and this enjoys the special protection. But they are the most important rights, and those rights which are found in the Constitution of India And in the constitution also at a special place, that is part 3, that means from 12 to 35. So those rights which have been placed in the constitution itself and not everywhere in the constitution, only at a particular place, and that is part 3. And part 3 means article 12 to 35, they are called fundamental rights. Right to freedom, right to equality, 6 such rights that we are going to discuss. So this is fundamental right, part 3, and in the constitution. Those rights which are found in the constitution, so these are also found in the constitution, but outside part 3. So let us see what is the difference between here fundamental and constitutional. Fundamental rights are also found in the, but in the, and constitutional rights are also found in the constitution, but outside part 3. Just take some examples. Article 3. This is right to property, right to acquire, hold and dispute property. So right to property, that we call right to property, found in article 300A as a right. A article is not included in part 3, and it is not between 12 to 35 article, that is part 3. So but it is in the constitution. So what is today the status of right to property? Constitutional right. Similarly, article 301, right to interstate trade, that is again a constitutional right. So there are many such rights that have been given to citizens, and they are mentioned in the constitution, but outside part 3, that is called a constitutional right. So hope you got the difference between fundamental, which is constitution, but part 3 versus outside part 3. Now comes legal or statutory rights. Legal or statutory rights are those rights which are not found in the constitution. That means they are nowhere placed in the constitution, but still the citizens enjoy those rights and they exercise those rights in India. For example, maternity right of women, maternity, for example, of working women's maternity rights has not been mentioned in part 3, so not a fundamental right. Has nowhere in the constitution mentioned as a fundamental, as a right, maybe a directive, but not as a right. Yes, I will come to that, Sachin. A legal right versus that, I will come. Just wait. I will, because that is a very relevant thing. Few rights are debated. So that I will come. But first let us get the concept. What is actually this? Then I will come to that question that you have asked. Good question. Or statutory rights are those rights which do not have a place in the constitution. So constitution, they have not been mentioned, but still the citizens enjoy. For example, maternity leave, right? And the maternity leave is a right for the working women. It is not a charity of the state. It is not that lady professor will go to the principal, sir, please give me as a charity maternity. No, it is right. You have to grant. Now paternity leave is also a right at various places. So maternity leave or paternity leave, that is nowhere mentioned in the constitution as citizens have that. From that comes, of course, that comes from the law or statute of the constitution. Law or statute of the parliament or legislature. Statute of the parliament, that means parliament has passed a law. In certain states, state legislature has passed law, and that law gives the right to maternity leave. So this is a legal right. Now let us first conceptually try to differentiate between these three, and then I will come to those debated rights like right to property. उसमें exam में आता है कि whether it is a legal or constitutional, there is a confusion. Right to vote, twice or thrice in UPSC exams the questions have been asked whether it is a legal or constitutional. That debated rights I would come. Right to information, I will come to those issues also, but first we have to conceptually a set of rights. So fundamental right, again see, those rights which are found in the constitution and at a specific part 3. Constitutional rights, those rights which are found in the constitution but outside part 3, right to property, right to interstate trade, and thirdly legal or statutory rights. Those rights which are nowhere mentioned in the constitution but still citizens enjoy those rights, exercise those rights because parliament has enacted law or statute, and that enacted law or statute empowers the citizen to exercise that right. We saw matters of the right to service, etc. Now there are certain rights which are debated. For example, right to vote. I am starting with this because in UPSC thrice question has been asked on this, right to vote, and there may be 4 options. Right, constitutional right, legal right, and none of the. Now fundamental right definitely it is not. So first to hoga hi nahi. But there is a great debate whether it is a constitutional right or whether it is a legal right. Why? Some claim that it is a constitutional right because right to vote flows from Article 326 of our constitution. 326 talks of universal adult suffrage. No person above the age of 18 years, all persons above the age of 18 years and their names shall be included in the voter list. So in a way that is voting right. So on the basis of Article 326, it appears to be a constitutional rights, but Parliament has passed a law and that is called Representation of People Act 1951. Now this RPA, Representation of People, this RPA or Representation of People Act is a legislation of Parliament. It is a law of Parliament. It is statute, enacted law. And in that statute, it is clearly mentioned that every adult citizen shall have a right to vote. So here it becomes legal right, see. So from one perspective it is constitutional, from other perspective it is legal. So it can be both. If we are to subjectively respond, I am saying that if I am to given an opportunity in the mains exam, if in the prelims I have to tick A, B, C or D, then I cannot say both. Both is not the option, none of them. Here we will give first preference to legal right. Do remember, we will give first preference to legal right because the commission also takes it as, and Supreme Court in Kuldeep case and other cases has clearly said yes, voting has a reference in the constitution but as a right, it has been mentioned in the parliamentary law. So voting right को कभी अगर हमें priority के आधार पे बताना, both if answer then both is correct. But if there is no answer like both, and if we have to choose between constitutional right and legal right, and that is regarding right to vote, then what shall be your first preference always? Right to vote is primarily a legal right. Supreme Court also says that, and commissions also accept that answer as the correct answer. So first disputed right is right to vote, maybe two rights from two different angles, but in prelims, in objective response, what we have to say, it is a legal right, because in that parliamentary statute everything has been explained. Eligibility, ineligibility, whereas Article 326 only says that name of every adult person shall be included in the voter list. Ineligibility, XYZ not mentioned. So voting right is a legal right primarily, otherwise it is a constitutional also, but first preference to legal. Second is right to information. अभी मेंस में भी सेंट्रल इंफॉर्मेशन कमीशन पर एक सवाल आया, RTI, Right to Information Act, RTI, Right to Information, sorry. Now there are again two viewpoints. Some say it is a fundamental right and others say it is legal or statutory right. So let us see, we should give priority to legal or fundamental. Why it is a fundamental right, or why some consider it to be a fundamental right? Because Supreme Court's pronouncements that under Article 19, citizens have the right to be informed. Citizens have right to get information under Article 19, because if I have information from government, then only I can properly exercise my right of thought and expression. मेरे पास सारा matter ही नहीं है farm bill का, so how can I say that farm bill is good or bad? For that I need the draft of farm bill. So for proper thought and proper expression, to analyze and then to express, I need certain documents, I need certain information from government, and therefore Supreme Court has held that under Article 19, citizens have right to be informed. So some say this is the source of right to information, and therefore RTI a fundamental right. But why it is legal? Because our parliament has passed an act, and that is called RTI Act, Right to Information Act 2005. RTI Act or Right to Information Act 2005. Now this Act or Right to Information Act clearly mentions that right to information shall be given to citizens. So here as a right, and what will be the conditions, PIO, everything is mentioned. If the government or the official doesn't provide information, then is the remedy, everything is mentioned in this. So again, it is fundamental also legal. But if we are to choose among these two, if a question on choice comes, इस पे अभी IAS में सवाल नहीं आया, वोट पे आया, but may come a सवाल on art also, then here also you have to give first preference to legal. That means primarily it is a legal right, because as a right clearly elaborated here. What are the conditions in which get information, and what are the exception to this? Defense का नहीं मांग सकता information. I cannot say that what are the nuclear installations of India, where BrahMos is deployed. I cannot ask. But yes, I can ask what was the cutoff in Delhi University in 2020 admissions. So depends what is the purview, all those things. If somebody doesn't give information, then whom I would be complaining. So remember, if first preference is given to RTI, then you must give legal right. Then third is the right to property. Right to property in some books, you will find it as constitutional right. And at some places, you will find it as a legal right. Why? Constitutional right, because clearly mentioned in Article 300A. Right to acquire, hold and dispose property. I can earn property, that is acquisition. I can hold property, बना सकता हूँ, घर बना सकता हूँ, that is hold. And right to dispose, I can sell that also, that is dispose. So property is a right, 300A. But legal right, because Parliament through 44th Amendment used its power and took it from part 3. Earlier it was in part 3, fundamental वाले में था, and then placed it in part 12, article 300A. So some would say that it is actually now the creation of Parliament. Why creation of Parliament? Because Parliament could have completely abrogated this, लिख देता कि right to property does not exist, or article 31, that was right to property, and 19 clause 1 subclause F, that could have completely been deleted. So that rights could have completely been gone. But no, Parliament took it from 31 and placed it at another place of constitution. So ultimately this has been done by the legislation. So some would say legal and some would say constitutional, but both are correct. But if we are to choose, again I am saying be very prudent, practical as far as competitive exams are concerned, because if you have appeared in the competitive exams, UPSC and other PCS exams, and if you see the question booklet and even the notification that is published in the Gazette of India, so there you will find certain instructions in the question book also, जो exam hall में मिलता है. And what would be one of the instructions? Candidates are expected to mark the most appropriate answer. They are not saying that 100% correct answer, most appropriate. That means constitutional is also correct, legal is also correct, but what is the most appropriate? So most appropriate we will mark as constitutional, because though it has been done by the Parliament, but where it is placed? The Constitution. So first preference goes to constitutional, and if constitutional is not there in the option, then legal also will work. For example, fundamental right, legal right, and you have to choose between this, then of course right to property is a legal right. But if there is third option, constitutional right, then we will go by constitutional right. That is the first preference. So hope you got all this. Again come to our main topic, what is fundamental right? And we saw that fundamental rights are those rights which are essential for moral and material development. They are found in part 3, article 12 to 35. Constitutional rights, they are found in the constitution but outside part 3. And 300A, right to property, article 301, interstate trade. And then legal or statutory rights, those rights which are not having direct reference in the constitution as rights, but they have decisions by the legislation of Parliament or state legislature, and that is called legal or statutory rights, like right to vote or right to information, maternity, various such, right to service. So this is various rights in India. Now again let us come to the very definition of fundamental rights. What we had seen, that fundamental rights are those rights which are essential for special protection. They have superior status. in the constitution, they enjoy special protection of the constitution. So what is superior status and what is that special protection that they enjoy? Now we are, so first part we discuss material, now we are discussing special, कैसे वो दूसरे से different है, how they are superior to other rights. So write down, fundamental rights enjoy special protection of constitution in the following ways. Fundamental rights enjoy special protection of the constitution in the following ways. First, if a fundamental right is violated, then the victim can directly approach. If a fundamental right is violated, then the victim can directly approach the Supreme Court of India. Under Article 32. There are 5 writs that we will discuss later. What is Article 32? But here, if a fundamental right is violated, then the victim can directly approach the Supreme Court. That means this is the first facility that fundamental right enjoys, but not other rights. That means if my fundamental right is violated, for example, right to speech and expression is a fundamental right. So I am running a news channel or YouTube channel, and arbitrarily, and it criticizes a government on, and it is a healthy criticism, but arbitrarily that this channel is banned and this article has to be deleted or I am put into jail, then this is a violation of my fundamental right. And what remedy do I have? I have the right to directly move to Supreme Court, none inferior court, Supreme Court. And Supreme Court will take cognizance of this and will enforce my rights if it is encroached unconstitutionally. So, fundamental right is violated, you can directly approach the Supreme Court. But for example, if my legal right or constitutional right is violated, if my property is taken arbitrarily, so that is violation of right. Government comes and expels from my house, says that now it will be a Janata Darbar office, anything. So of course this is violation of my constitutional right to property. You cannot. Then what I can do? I cannot directly go to Supreme Court because this is not a fundamental right. At the most, I can go to the High Court. So what is the first special protection that fundamental rights enjoy? In case of violation of fundamental right, the victim can directly move to the Supreme Court of India. But in case of violation of right other than fundamental rights, the victim does not have the right to directly move to the Supreme Court of India. Then second, special protection, write down. A fundamental right can be suspended. A fundamental right can be suspended only during special circumstances. A fundamental right can be suspended only during special circumstances and only through the special procedure that is laid down in the Constitution itself. Write down, I have seen the question, I will respond to that. Only procedure that is laid down in the Constitution. So let us see what is the second. First was enforcement. Now comes the suspension. Suspension means right to freedom has been suspended. So cannot be done arbitrarily. It can be done only, and we will discuss these articles later, how fundamental rights will be suspended. So there are 2 specific articles, Article 358 and Article 359, and you can suspend a fundamental right only using the procedure that has been laid down in the Article 358 and in Article 359. And there 358, 359 gives conditions that only in these conditions you can suspend. Only during national assembly, national emergency, not assembly. Only during national emergency, fundamental rights can be suspended holistically. And there is procedure. So every now and then you cannot suspend it. But A right other than fundamental right is at the will of the executive, and it can be suspended at time and without any specific constitutional procedure by the executive. Just take one example. Ramnath Kovind, the President of India. For example, I am saying for example, I know he is a lawyer and but for example, the President of India issues two orders. First order, today he issues, for example, two orders and says, right to thought and expression is suspended. No newspaper shall be published, because press is also a fundamental right within the purview of expression. No news channel will be broadcasted, means all suspended for 10 days. There is no national emergency in the country, but he says for 10 days, no newspaper published. And second order, for next 3 months, right to property. For next 3 months, the sale and purchase of any property is suspended. आगे 3 महीने तक कोई खरीद बिक्री नहीं होगी. So disposing property is also a right, not a fundamental right, but and holding property, disposing. So a constitutional right to dispose property is suspended for 3 months. Now second order is correct. No national emergency, still the sale and purchase of property can be suspended if corruption anything is found. But all the newspapers cannot be suspended during the time of peace. Yes, a particular newspaper can, but by and large if you are national. So that is the difference. 358, 359. So first is enforcement and second is suspension. Then third is special protection. Write down third. Fundamental rights. Fundamental rights can be amended only, fundamental right can be amended only by special majority. Fundamental rights can be amended only by special majority. Fundamental right can be amended only by special majority. That means if you want to amend a fundamental right, then it has to be done by special majority. Can be amended only by special majority. What is that special majority? You know everything, 2/3 of present and voting members, which is not less than half of the, so types of majority, everything you know, and later on I will explain also. So these are the special protection that a fundamental right enjoys. So here we dealt with some basic questions of fundamental rights. What is a fundamental right? How fundamental rights are different from legal and constitutional rights? And what is the special protection that Constitution gives to fundamental rights? Now let us discuss some other aspects of fundamental right. So here we saw few aspects of fundamental right. Now let me see the question that somebody has asked, Subham has asked. But for the purpose of development, government can take our property. Yes, arbitrarily cannot take. But for development purpose it can take. But for that, I have to be paid compensation. Land Acquisition Act says that I have to pay. Yes, my land can be taken. As mein Janta Darbar karna, get out. It has to be taken with some logic, and I have to be paid compensation also. So arbitrarily cannot be taken. That is the thing. So if a national highway is to be constructed, no problem, it will be taken. But for example, ki Modi ji has to expand his own paternal garden. For that you cannot take. That is not. So arbitrarily it cannot be taken. That is correct. So here what we saw, what is fundamental right and what are other rights, how fundamental rights enjoy special protection. Now give one heading, features of fundamental rights or characteristics. Features or characteristics of fundamental rights. Features or characteristics of fundamental rights. So write down first. Fundamental rights are not absolute. Fundamental rights are not absolute or unlimited. Fundamental rights are not absolute or unlimited. Fundamental rights are not absolute or unlimited. What is the meaning of absolute? Means having no restriction. But that is not the case. Our fundamental rights are not absolute and they are not unlimited, means they are limited. So I have freedom of speech and expression, but arbitrarily I cannot abuse you. So every or most of the fundamental rights are with, and in a civilized society, you cannot give absolute right. Absolute. So you have the right to drive on the road, but you have to respect moving on their foot also. So therefore, first, no fundamental right. Fundamental rights are not absolute; they are limited. Then second characteristic, are enforceable. Fundamental rights are enforceable. fundamental rights are enforceable. So enforceable, already in the preamble we saw this word. Enforceable means they are binding upon government, and if a fundamental right is violated by the government or by any other person, then I have the right to move Supreme Court through Article 32, and then Supreme Court will protect my rights. So fundamental rights are enforceable. They are not like preamble. They are actually enforceable, and therefore government is bound to respect my rights. So they are enforceable. Enforceable, preamble में सारा डेफिनेशन लिखवा दिया है, इसलिए यहाँ पे नहीं लिखवा है. Then third, fundamental rights are negative in nature. This is something unique. Fundamental rights are negative in nature. Fundamental rights are negative in nature. Negative in nature. So let us see negative. Moral development, material development is negative thing. Yes. In the prelims, if 4 characteristics come, then this is to be taken as true. True. Believe me, true. And if you say false, then 1 number कम हो जाएगा आपका. So remember, 2 number. Always say yes. Fundamental rights are negative in nature. But somebody if asks, that's such a great thing, negative, we'll say yes, negative. But negative doesn't always mean bad. Negative only means that these fundamental rights have been expressed negatively. These fundamental rights have been mentioned in the Constitution with a negative connotation. Let us see. It means that, for example, if you see Article 14, no person shall be deprived of XYZ. So no person shall be deprived, not be done. So it is good thing that equality should prevail. No person shall be deprived of equality before law. But no. Similarly, Article 15, a state shall not discriminate among its citizens on the basis of religion, race, caste. Shall not discriminate. That means the way of expression is no. Try to discriminate. But it is negative. So negative doesn't mean bad. Negative only means that the way of expression is no. Similarly, Article 16, a state shall not discriminate on the basis of XYZ in public employment. All the articles we will read one by one. Pura reservation, everything we will go through. But here just I am taking the example, the state shall not. Yes, very good. Why the state will discriminate? But shall not, no. So because of this word no, they are called negative. Article 17, no to untouchability. Very good. Why untouchability? But no word is so negative. Article 18, no titles. Titles shall not be conferred. So therefore I say that third characteristic of fundamental rights is that they are negative in nature. That doesn't mean they are bad, but the way of expression is negative. So this also you have to take as a correct quality of or feature. Then fourth, write down fourth. Some fundamental rights are available to citizens only. Some fundamental rights are available to citizens only, whereas some fundamental rights are available to citizens only, whereas some fundamental rights are both to some fundamental rights are available to citizens only, whereas some fundamental rights are available both to citizens and foreigners. Now you see, this is also one of the features where some of the fundamental rights exclusively for citizens, foreigners do not enjoy, but some are for citizens as well as for, that means citizens all rights are for citizens, but few rights are for foreigners also. Take some example. Article 15, Article 16, Article 19. They are only for citizens, foreigners do not enjoy. Whereas Article 14, Article 21, they are available both to foreigners and citizens. Article 14 and Article 21, they are available to both citizens and foreigners. So let us see that with citizens. Article 15, states shall not discriminate among citizens on the religion, race, caste at public places. That means foreigners can be discriminated at public places, and actually the government discriminates. Red Fort, Taj Mahal. If a citizen goes to buys a ticket, then maybe 20 rupees, 30 rupees, I don't know, 50 to 100 rupees. But if a foreigner goes to buy the ticket of the same monument, 500 rupees, 1000 rupees, discrimination at public place, but this can be done. Article 16, employment under the state, that means government jobs. Citizens have the right to compete and non-discrimination, religion, race, etc. with citizens only. But if British national want to appear in the IAS exam, he can be stopped. Now Nepalis, Gorkha regiment आपने देखा,